We will now have the first of our two keynote addresses for this year's Nuremberg Forum, which will be delivered by Dr. Silvia Fernández de Gurmendi. Dr. Fernández was the third president of the International Criminal Court from 2015 to 2018 and served as a judge of the ICC from 2009 to 2018. After the end of her judicial mandate, she was also the president of the Assembly of States Parties of the International Criminal Court and was instrumental in the setting up of the ICC in general, having served as the vice president of the Committee of the Whole at the Rome Conference. She was also the Director General of Human Rights at the Ministry of Foreign Affairs of the Republic of Argentina and is very much a guide here for us as the president of the Advisory Council of the International Nuremberg Principles Academy. Judge Fernández.
So, greetings to you again. I'm honored to share some reflections with you in this historic room. 80 years ago, on 20th November 1945, at 10 a.m., the defendants charged by the prosecution of the Nuremberg International Military Tribunal were led into this very same room and were ushered into the specially adapted dock here, flanked by American military police. The entire day was taken up by the reading of a 24,000-word indictment, which included acts constituting crimes against humanity, war crimes, and crimes against peace. The British president of the tribunal, Lord Justice Geoffrey Lawrence, comments the proceedings describing the trial as, I quote, unique in the history of the jurisprudence of the world and of supreme importance to millions of people all over the globe. The first trial lasted more than 10 months, overseen by judges from the 4 founding nations: Britain, the United States, France, and the Soviet Union. Ultimately, of the 24 defendants, 12 were sentenced to death, 7 received prison sentences ranging from 10 years to life, 3 were acquitted, and in 2 cases, no decision was reached. From its inception, the Nuremberg Tribunal and its judgments were controversial. Debates surrounded its legality and legitimacy, including arguments regarding the violation of the principle of non-retroactivity of criminal law, procedural shortcomings, and most persistently, the accusation that the tribunal represented victor's justice. Though the tribunal was established by the 1945 London Agreement signed by the 4 major Allied powers, it is significant to note that by early 1946, 19 additional countries from Europe, Latin America, Africa, and Asia had adhered to the agreement. But the core criticism was that the tribunal breached fundamental principles of justice by only judging one side, thus applying selective justice, a concept that resonates very much today. Indeed, atrocities committed by the victors, such as the bombings of cities in Germany and Japan and the nuclear destruction of Hiroshima and Nagasaki, were not addressed by either the Nuremberg or Tokyo tribunals. Despite its shortcomings, the Nuremberg Tribunal was a remarkable achievement that paved the way for future advancements in accountability for the gravest crimes. The initial consolidation of the Nuremberg legacy came through its endorsement by the newly established United Nations. In 1946, during its first session, the General Assembly affirmed the principles of international law recognized by the Charter and judgment of the Nuremberg Tribunal and called for their codification. This led to the 1950 adoption of the 7 Nuremberg Principles by the International Law Commission, which remains central to international criminal law to this day. the legacy of Nuremberg further influenced the developments of crucial international instruments such as the Genocide Convention, the Geneva Conventions, and the Torture Convention, all of which uphold criminal responsibility for the gravest crimes. In the immediate post-war period, thousands of German perpetrators and their collaborators faced trials in Germany and other occupied or collaborating nations. However, efforts to bring to justice those responsible for massive crimes unrelated to the war, particularly those committed under dictatorial regimes against civilian populations in subsequent decades, were far less frequent. An important and almost unprecedented trial was conducted in 1985 in Argentina against the military juntas that had ruled my country from 1976 to 1982. It was a crucial component of our transition to democracy, as it has just been said in this previous panel. This year, we commemorate the 40th anniversary of this trial, our local Nuremberg. At the international level, criminal justice hibernated until the end of the Cold War allowed for new institutional breakthroughs 50 years after the Nuremberg trial, the establishment of the ad hoc tribunals, and most importantly, the creation of the first permanent international criminal jurisdiction, the ICC, with global aspiration. The first tribunal to be created was the International Tribunal for Former Yugoslavia in 1993, followed by the International Tribunal for Rwanda in 1994. For both tribunals, there was a deliberate effort to address the shortcomings of the post-war military tribunals and avoid charges of retroactive punishment. In his 1993 report to the Security Council, the UN Secretary General noted that the tribunal to be created for the former Yugoslavia should only apply rules of international humanitarian law that were beyond any doubt part of customary law. Also, the new tribunals were held out as a progressive development over Nuremberg because they had been created by the UN Security Council acting in the name of the international community rather than by one or more of the victors. And for both tribunals, the statute specified that the prosecutor was to act independently as a separate organ of the international tribunal. He or she, said the statute, shall not seek or receive instructions from any government or from any other source. The tribunals themselves made efforts to differentiate themselves from its predecessors. An early decision of the ICTY in the Tadic case stated in 1995, that I quote, "The Nuremberg and Tokyo trials have been characterized as victor's justice because only the vanquished were charged with violations of international humanitarian law, and the defendants were prosecuted and punished for crimes expressly defined in an instrument adopted by the victors at the conclusion of the war. Therefore, the International Tribunal is distinct from its closest precedents." The founders of International Criminal Court, the ICC, were also very conscious of the same concerns. An important part of our discussions focused on the need to uphold the principle of legality, avoid selective justice, and promote the independence of the court from political actors, including the Security Council of the United Nations. Adequate independence from this body was deemed vital to ensure the court's impartiality. Unlike its predecessors, the court was advanced by a coalition primarily composed of small and medium-sized countries in collaboration with civil society organizations. Furthermore, the architects of the court believed that upholding the principle of legality required more than ensuring non-retroactivity of the law. They also sought to define crimes, general principles of criminal law, and applicable penalties in greater detail. Therefore, and for the first time in the history of international criminal law, states embarked in an ambitious codification process of the legal and procedural framework to be applied by the court. And thanks to this process, states developed the first comprehensive multilateral binding definitions of war crimes and crimes against humanity. The drafters preferred not to touch the definition of genocide contained in the Genocide Convention, which, despite its alleged shortcomings, was by then recognized as reflecting customary law. And the definition of aggression would come later. During the negotiations of the Rome Statute, the debate about the independence of the court and selective justice centered in the triggering mechanisms to initiate an investigation. In order to avoid political interference, it was decided that the prosecutor would not depend on referrals or situations by the states or the Security Council and would be able to initiate an investigation proprio motu on his own initiative, based on information provided by any source with the authorization of pretrial judges. Furthermore, after the adoption of the statute, the rules of procedure clarified that the acceptance of jurisdiction of the court by a non-party would imply acceptance of jurisdiction over all relevant crimes in the situation. This was a provision proposed by the United States, which considered that justice à la carte should not be allowed. Upon the entry into force of the Rome Statute and the election of the judges and the prosecutor, investigations started. Slowly and surely, and sometimes painfully, the court demonstrated that it could investigate and prosecute in the real world. It also proved that the innovative and then controversial victims regime that had been included for the first time in the Rome Statute was a difficult but workable scheme. With time, this system that allows for the participation and reparations of victims would be incorporated by other tribunals and has now become an integral part of international criminal justice. So proceedings of the court multiplied alongside many others carried out by the ad hoc tribunals and other international or hybrid tribunals that were subsequently created. Through 3 decades of sustained accountability efforts, the concept of justice for the gravest crimes ended being firmly entrenched as an essential component of transitional justice and conflict resolution. Contrary to decades of prevailing impunity, there is now an expectation that justice will be done for the gravest crimes. The question is no longer if there will be justice, but when and how. This growing demand for justice has also influenced the manner in which human rights organizations and institutions work. Today, a larger number of organizations are dedicating time and efforts to collect information on alleged crimes. They have become not only more numerous, but also more adept at gathering evidence in a manner that may be more reliable and useful in criminal proceedings. This focus on promoting human rights by assisting in accountability efforts has also influenced the scope and modalities of work of intergovernmental organizations, United Nations mandated investigative bodies, such as fact-finding missions and commissions of inquiry, are increasingly being used to respond to situations of serious violations of international humanitarian law and international human rights law, and to promote and to promote accountability and counter impunity. Progressively, the commissioners, as well as individuals selected to assist them, have expertise in international criminal law. The recommendations of these commissions are now often based on norms, methodology, and evidentiary thresholds based on international criminal law provisions and practice, including provisions of the Rome Statute. In two situations, Syria and Myanmar, new mechanisms were established with the explicit mandate of collecting, preserving, and analyzing evidence to assist in the investigation and prosecution of those responsible for the most serious crimes. These efforts to expand the pathways to justice also demonstrate that accountability is currently considered as an indispensable response to serious human rights violations and international crimes. So 3 decades of international criminal justice also gave a major boost to national justice. And we now witness a proliferation of national proceedings for international crimes. According to the 2025 report of the organization Trial International, with more than 130 matters under investigation or judicial proceedings, extraterritorial and universal jurisdiction cases continue to be a central pillar of the global fight against impunity in 2024. At least 36 new cases were opened or made public, and 27 convictions were entered over the course of that year. Civil society organizations are involved in more than half of ongoing proceedings, either as complainants, providing information, or collaborating with investigations by national authorities, supporting complainants, or participating as plaintiffs. Some consider that through this combination of international and national proceedings, a global system or ecosystem of justice is emerging. Unfortunately, despite the numerous developments, a general pattern of accountability remains elusive. Entire situations of international crimes are unaddressed, still today. For these reasons, justice for international crimes continues to be perceived as selective justice. That is, justice that applies to some but not to others, and that it is influenced by the interests of some states. Indeed, there are significant gaps and restrictions at the national and international level. At the national level, the figures I just gave you are encouraging, but they are not representative of a truly global trend. Most cases continue to be concentrated in a few Western countries, with Argentina as a notable non-Western exception. At the international level, the limitations are well known. The ICC is the only permanent court with global aspirations, but it is restricted by its jurisdictional regime and the lack of universal participation in its founding treaty. The initial focus of the ICC on Africa for more than a decade intensified the perception of selective justice, and this perception persists today despite the expansion of its investigations to all regions of the world. The inability of the court to address all crimes equally affects its effectiveness and legitimacy, and it is therefore not surprising that enhancing the universality of the ICC has always been a top priority for the court and the Assembly of State Parties. It should remain so because the application of selective justice, no matter the technical justifications, is extremely negative for the credibility of the court. Unfortunately, state parties themselves contribute to the perception of bias, when they refuse to cooperate with all investigations and prosecutions in an equal manner. While this is not a new problem, the reluctance to cooperate with recent arrest warrants issued in the Ukraine and Palestine situations has exposed with striking clarity the weaknesses of justice commitments when they conflict with other political goals or interests. This willingness to apply justice only when it aligns with the state's interest is a very worrying trend. Even more so because it occurs at a particularly difficult moment in which non-state parties attack and threat the court and its officials and those cooperating with it. The court, as you all know, has been the object of a massive and sophisticated cyber attack clearly intended to obtain confidential information. In addition, the prosecutor, deputy prosecutors, and several judges of the court are under sanctions imposed by the US administration as a reprisal for its investigations in Afghanistan and Palestine. Some of them have also been subject to criminal proceedings and arrest warrants by the Russian Federation in response to the arrest warrants issued in Ukraine. And more sanctions targeting ICC officials or the institution itself could be imposed at any moment. Civil society organizations and human rights defenders cooperating with the court are also being targeted. These attacks are not only corrosive for the court itself, they also present a significant challenge to the international community and the broader system of justice and the rule of law. If the court fails to receive adequate protection, there is a real risk that similar assaults could be directed towards other organizations, individuals holding United Nations mandates, or even national judges and officials. In fact, such incidents have already begun to occur, illustrating the vulnerability of the entire system when any one of its pillars is undermined. In light of these negative developments, we must ask ourselves whether we are commemorating the first 80 years in the ongoing consolidation of international criminal justice, or whether we are instead witnessing the decline of this path. In other words, are we at the beginning or at the end of constructing a justice and rule of law system? When I look at the courts and how its officials have reacted to the attacks, I cannot but be optimistic. They have demonstrated extraordinary resilience and courage. Investigations and judicial proceedings continue. So do their efforts to improve the internal functioning, mitigate the impact of economic sanctions, and enhance the security of all concerned. However, it is obvious that the court cannot protect itself on its own. It needs the support and solidarity of the international community, starting with its own state parties and civil society organizations. Having served recently as president of the Assembly of State Parties, I have seen firsthand the challenges in securing a robust, collective response to threats and attacks in our turbulent times. The 125 state parties to the Rome Statute represent a diversity of interests and alliances, reflecting the wider polarization of the world. Nevertheless, many of them do share common values and should be able to unite, mobilize political support, and coordinate actions to protect the court in these difficult times. in addition to other measures that states could take individually or regionally in partnership with civil society. So it is to be hoped that states and civil society will find ways to increase their support. Their solidarity and effective action are essential to safeguard the court and to preserve the legacy of Nuremberg beyond its first 80 years for the generations to come. I thank you for your attention.
Thank you very much, Judge Fernández, for your extremely timely and pertinent remarks, and for raising a lot of important issues which I'm sure will be further examined by the ensuing discussions. We will now have our final keynote address of the Nuremberg Forum 2025, which will be delivered by Elinor Hammarskjöld, the Under-Secretary General for Legal Affairs and the Legal Counsel of the United Nations. Before taking office this year in February as the Legal Counsel of the United Nations, she previously served as the Director General for Legal Affairs of the Swedish Ministry for Foreign Affairs and as the head of its legal department. She has over 30 years of experience in security policy, international law, human rights, and treaty law, and served as Ambassador of Sweden to Israel and at the Permanent Mission of Sweden to the United Nations in New York. Thank you, Under-Secretary General.
Excellencies, distinguished guests, ladies and gentlemen, I'm honored to be with you today and to deliver this keynote address on behalf of the Secretary General of the United Nations. At the outset, I'd like to thank the International Nuremberg Principles Academy and Professor Safferling for the invitation for organizing this timely event, and to thank also and join others in thanking our kind hosts here in Nuremberg, the judiciary and the city, and of course the government of the Federal Republic of Germany and Director General von Uslar Gleichen. It's an honor to speak after Dr. Fernández de Gurmendi, a friend whose career I have followed and had the honor to follow for probably about 30 years, I think. And like her, I would like to address some of the developments leading us through the 80 years that we're discussing here at the forum, perhaps permitted to add a little extra emphasis on the role of the United Nations along this process and journey. Ladies and gentlemen, 80 years ago, the world was at a crossroads. At the end of World War II, it was clear that there had to be more than peace. There had to be justice. As we've heard, the London Charter was adopted and the Nuremberg Tribunal courtrooms were opened. From these rooms, we saw the beginning of a new era in international criminal law, an era in which individuals, including the most powerful, are held accountable. It was the start of a series of efforts that still shape our pursuit of accountability today. The United Nations has been at the center of these efforts, starting, as was mentioned, with the General Assembly's affirmation of the Nuremberg Principles in 1946 and the International Law Commission's formulation of these principles in 1950. These, of course, are the principles from which this Academy draws its strength. It is both memory and mission. Memory in honoring a first stand against impunity, and mission in advancing the cause of accountability today by training, research, and dialogue. This forum is an opportunity to reflect on Nuremberg, not perhaps as a static and perfect example, but as a legacy and part of a journey which continues today. If I might pick up the question posed at the beginning of today's forum by Professor Safferling, is all this still relevant? Is international law still relevant? Is the work to ensure accountability still relevant? My answer would be yes. Are there challenges? Are there violations? Are there backtracking? Yes, also. I think for those of us working in this field and who want to stand up for international law and the defense of accountability efforts, I see a dual task, a dual challenge. One is to defend what we have achieved, and it's been spoken to eloquently already, and I'll come back to some of the other steps that we've already seen. And the second is to preserve the space, legal, political, to continue to develop and to continue that journey beyond the defense. And I'll come back to that too. As we've heard, Nuremberg ignited a movement that included the adoption of the Genocide Convention and the Universal Declaration of Human Rights, surged forward with the adoption of the Geneva Conventions in 1949, and carried through the adoption of the 2 Human Rights Covenants in 1966, the additional protocols to the Geneva Conventions in 1977 and beyond. In this, the role of the UN was fundamental, first as a forum for adoption of most of these international instruments, also as a forum for treaty-based legal and political follow-up to international obligations, and eventually through the establishment of international criminal tribunals for the prosecution of those responsible for the serious crimes under international instruments. When the initiatives to establish the tribunals for former Yugoslavia and Rwanda were on the table, the Secretary General at the time and the UN Office for Legal Affairs were active in contributing to designing these new tribunals. This required new legal analysis, and one important point not already mentioned but relevant, I think, is that the Secretariat and subsequently the Security Council itself took the position that establishing these tribunals through a Chapter 7 resolution under the Charter of the UN was both legally justified and the most expeditious and effective path forward, ensuring that all states would be bound to comply. And as we know, both tribunals established foundational precedents and developed international criminal law in many areas, including in the law of the armed conflict, crimes against humanity, genocide, and breaking a culture of impunity surrounding wartime sexual violence. And as we know, all of these steps, from Nuremberg, Tokyo, the ICTY, the ICTR, contributed to the process that eventually led us to the establishment of the International Criminal Court through the Rome Statute in 1998. That was a long endeavor for a permanent and effective system of international criminal justice. It was created to ensure continuity in international criminal jurisdiction and consistency in international criminal jurisprudence. Today, as atrocity crimes continue to occur, the ICC stands and continues to stand as a challenge to impunity. It's created to stand impartial and indifferent to status, but it is also currently under threat. The strength and the independence of the court depend heavily on the support it gets from its states parties to the statute and the broader international community working for accountability. At the start of the third millennium, the international criminal justice movement entered a phase of increasingly bringing justice closer to the communities affected. And we saw then a phase of creation of hybrid criminal courts. That started with the creation of the Special Court for Sierra Leone to put an end to the impunity that defined the country's brutal 11-year civil war. Shortly after, the extraordinary chambers in the courts of Cambodia was established to ensure that the crimes of the Khmer Rouge would not be buried under the ashes of impunity. Both those tribunals, as well as the Special Tribunal for Lebanon, established in 2009, were the result of negotiations between the UN and the concerned governments, leading to the creation of these hybrid courts with international and national components working hand in hand. We know that the development of these instruments and the establishment of an architecture have been decades in the making. But accountability is a long-term investment, and we can't evaluate it only through the adoption of formal structures and legal instruments. I think we will hear over these few days that it is the implementation and the delivery of justice that really matter. International courts and tribunals have delivered and continue to deliver justice. And even though the courtrooms of some of these courts and tribunals have closed or will close, the work of the justice lives on. As we know, some of the tribunals are now in their residual phase, but they still protect the witnesses who came forward. They still enforce sentences against convicted criminals. And as was mentioned, they still preserve the archives that tell the world and the communities affected what really happened. They are the memory of humanity's darkest chapters. I think we need to recognize that also these residual mechanisms are under strain, that resources are shrinking, that political support is being questioned, and that the risk of denial and historical revisionism is growing. And as doors start to close, new questions arise about the fate of the archives, the preservation of legacy, and how the lessons of justice will endure once the gavel falls silent. An important priority for my office is to do what we can to stand beside the residual mechanisms and to help them reach an orderly completion of their work. We want to preserve the legacy through outreach, through fundraising, and by encouraging continued support from member states. In Cambodia, the UN and the royal government have agreed that the extraordinary chambers will continue their residual functions for 2 more years. And beyond that, the government is taking an important step to establish a permanent, independent public institution, a living research centre, where the people can learn, reflect, and access the history of Cambodia's long journey towards justice. To pick up on the points eloquently made by President Gatti earlier, in relation to the international residual mechanism for criminal tribunals and in response to a request from the Security Council, the Secretariat will be providing the Council by the end of this year with a set of options. And that will be options to guarantee that the enforcement of sentences continues to be carried out independently, fairly, and in a cost-effective manner. Options for the transfer of the mechanism's vital function of assisting national jurisdictions. And finally, options for a permanent location for the archives of the ICTY and ICTR to safeguard their legacy. From all of these experiences, the international justice movement has learnt important lessons. It's inspired the empowerment of national systems and has brought global expertise to local courts, with the establishment of other internationally assisted models at the national level. It's also paved the way for an increasing emphasis within the UN of the establishment of non-judicial accountability mechanisms, including for Syria, for Myanmar, and for Iraq, to collect and preserve evidence, support accountability processes at the international, regional, and domestic level, and to keep the path to justice alive. Excellencies, distinguished guests, since Nuremberg, we've had many achievements and a lot of lessons learned. But we are still witnessing alarming developments of conflicts worldwide, in the Middle East, in the heart of Europe, in the Horn of Africa, and beyond. Civilians, including children, journalists, humanitarian workers, and UN personnel, are under attack and face unacceptable suffering and casualties. And, as all speakers so far have been clear about, at the same time as this development, we also see that the institutions that may provide accountability for crimes are also under threat, and that judges and human rights experts are threatened. And the UN has also expressed concern about the use of sanctions in respect of the exercise of official functions in and in cooperation with courts. And perhaps an additional risk is that in addition to explicit threats, there is an increase in hesitance, in risking the explicit support for accountability moving ahead. The Secretary General said last month in his words to the General Assembly that we must make a choice, an active choice, to reaffirm the imperative of international law, to reassert the centrality of multilateralism, to reinforce justice and human rights, and to recommit to the principles that gave rise to the UN. And that approach, I think, applies also to what we will be discussing here at this forum. I think it still is important to raise the need for consistent messaging that all states and parties to conflicts must honor their obligations under international law, that they must comply with judicial decisions. Accountability is not a challenge to peace. It's part of creating sustainable peace. And if I might pick up on a point made by Professor Mendes earlier, I think the importance of prevention is as key as it always has been. Within the UN, the mechanisms that you referred to, Professor, still continue their work. But it is important to recognize the chain between prevention and justice. So, what does the future hold? What about the future developments that I mentioned earlier? Well, one important and decisive step taken by the UN General Assembly is that we will convene a conference in 2028 and 2029 to elaborate and conclude a legally binding instrument on the prevention and punishment of crimes against humanity. This should be another milestone in a journey that started here in Nuremberg. While the Nuremberg Principles initially defined crimes against humanity in connection with crimes against peace and war crimes, the decision to develop a separate treaty on crimes against humanity will fill a lacuna in international law and signals that, rather than shrinking, international criminal law is extending its reach. And also that there is a will among member states to continue to work on multilateral agreements in the field of international criminal law. Another priority looking ahead will be to continue the efforts to support national jurisdictions worldwide through technical assistance, through capacity building. My office will certainly continue the work that we do to facilitate judicial cooperation in line with the organization's rules, to ensure that exchange of information and evidence strengthens justice. This includes cooperation with international courts and tribunals, including the ICC, in accordance with our relationship agreement between the UN and the court. It is also crucial to highlight the role of civil society, including this academy and other organizations, in carrying forth the cause of human rights and justice by research, capacity building, exchange of knowledge and expertise, and by building the pressure that, as Dr. Fernández de Gurmendi said, makes accountability unavoidable and not a choice. My final word would be for my fellow lawyers. I think our efforts, your efforts, continue to be indispensable to advance the cause of accountability, that the craft of the lawyer still makes a difference, to turn law into action, testimony into evidence, and evidence into justice. This will be as important and perhaps more important than ever. Thank you very much.